Meantime, gentlemen, I have some questions for you. And what we'll do is we'll address this to one of the speakers, and we'll get their response. And if the other member of the panel would like to weigh in and have some other point, please feel free to do so. So, Steve Nudelman, we're going to start with you. What happens if a party does assert a duplicative tort and contract claim? How does the economic loss rule apply?
Okay, typically what would happen in that case is it would be raised as a defense, if you would, by the answering party. They could assert it as an affirmative defense, but they could also make a motion. It's a strategy question. They could make a motion to dismiss the duplicative tort claim on the grounds of the economic loss rule. And I've done it plenty of times. I've seen it done plenty of times. And courts are not looking to add to their workload. If this is a clear example of a claim that is barred by the economic loss rule, that's an issue of law that could usually be readily decided, early on in the litigation without, anything beyond an early motion to dismiss.
Andrew Foti, do you have any thoughts on that, or you want to take a fresh question?
I'll just add to it. That was a great response. Just another thing to think about, thought-provoking for practitioners' tips. A lot of our contracts that we see in construction involve a waiver of jury trial, and rightfully so, because what juror do you really want to sit through and listen to all sorts of delay analysis and really sophisticated stuff? But if you are going to bring a tort claim and try to get around the economic loss rule, that is also an avenue for a jury question, and it does not, the waiver of jury trial would not be impacted. So on both sides of the aisle, if you want that jury because you think you have that type of case, think hard about whether or not you can bring in that negligence or that fraud count to get your jury trial. And on the other side, if you certainly do not want a jury trial and want this to be a bench, to Steve's point, I would definitely go with addressing this as a motion to dismiss as opposed to getting further down the line and waiting for a summary judgment or even as an affirmative defense.
Oh, thank you for that, Andrew. Let's go to a fresh question for you. So, Andrew, let's assume you have a contract between an owner and GC, and I'm going to assume GC is general contractor, that contains a clause that the contractor will act as a fiduciary of the owner. The owner claims that the contractor breached his fiduciary duty in dealing toward the benefit of the subcontractors instead of the owner. Can the owner bring a claim for breach of fiduciary duty in tort, or is that barred by the economic loss doctrine?
That's a very solid question there, and I would say it always depends on the facts, and again, drawing the line in the sand on what you can claim is the separate and independent tort, which would be, in this case, based on the hypothetical, the breach of fiduciary duty. If the parties have actually espoused through their contract what the rights and obligations are under that fiduciary duty that a contractor has taken to the owner, then the argument would be that the contract thus defines the duty and the fiduciary duty owed, which would then bar a tort claim for the same action because it's not separate and independent. So again, it's all how it's pled and how it's worded, but if you are going to describe it in contract, I think you would have a strong chance to get that dismissed.
Steve Nudelman will offer the same courtesy to you. Would you like to weigh in on that point?
No, I would have answered the same exact way.
All right. So, Steve, I have another question for you. How does a limitation of liability clause affect the economic loss rule?
Yeah, the issue there is I think I used the term backstop in the presentation. It helps to cap and put some certainty on the engineer or the design professional's exposure when they enter into a professional contract, so that in the event the economic loss rule is inapplicable or an exception kicks in, they're not on the hook for the full boat of tort damages that they otherwise would be on the hook for. their liability will be limited to a certain dollar amount. I've also seen limitation of liability clauses that are tied to the amount recovered by insurance, because sometimes, you know, when it's one of these things, if you're dealing particularly with an arm's length contract and you're negotiating back and forth between two equally sophisticated parties, a limitation of liability clause is a negotiated term. Just because in the microscopic print on some engineer's contract, it says that the liability is going to be $50,000, the amounts paid under this contract, doesn't necessarily mean that the other party who's signing it has to agree to that. You can negotiate that point back and forth. And again, the purpose from the engineer's point of view, and as it relates to the economic loss rule, is he or she is limiting what their exposure is. But again, that limitation is subject to negotiation.